There's a range of contract cases which make it clear that in most circumstances, once a contract is formed, it's too late to then introduce other terms and conditions to the contract. So, for instance, if you leave an item for repair and then while the item is being repaired, they send you a document called Terms of Business or something similar, then that document has no value at all. It's not part of the contract. But what if you went back to the same repairer the following week, and the week after that, and the week after that, and every time they sent you the same terms of business? Surely, eventually, you'd have to accept that you knew the repairers only wanted to do business on those terms, and so they'd become part of the contract. That's pretty much what happened in this case. Motorline was a car dealer, and from time to time they obtained temp staff from Hayes personnel. When a person was placed by Hayes, Hayes sent to the employer a terms document, which included, among other things, a term that if the temp worker was then hired full-time by the employer would have to pay Hayes an additional amount of money. A worker who was placed by Hayes was then engaged by a company close to Motorline, and one question for the court was whether the terms of business document was part of the contract. This was the 10th time that a Hayes personnel worker had been placed with Motorline, and therefore it was the 10th time that the terms of business had been sent to them. Hayes said that terms of business were part of the contract, but Motorline said they were not, because the document was not sent to them until after the contract had commenced. The magistrate who heard the action at first instance found that any reasonable person would consider that by the 10th repetition, the contract included the terms of business. The Court of Appeal agreed. Justice of Appeal Holmes said, "The learned primary judge properly applied an objective test, how a reasonable person would have responded to a series of letters enclosing the terms of business." As a result, terms which had formed part of the course of dealing were regarded as part of the contract.